full string.
Mhm.
All right, I am gonna allow it. It was eventually sent to her. Obviously, Attorney Mullen, if there are questions as to its authenticity, the respondent can certainly attack that with testimony. But as I can see it, it's an emailed ordinary course that she was copied on. I'm gonna let it stay in the record. So go ahead, Ms. Bertrand.
Okay, thank you. So I just wanted to, let me see. This is where I was CC'd. And then it just discusses that I reached out to my doctor and that since I'm doing well with my pregnancy at this point, they will be providing a note delaying my restrictions. The previous note that, was written months earlier. This is my first pregnancy. I did not know how I would be doing. Obviously, I'm trying to be as safe as I can and listening to the doctor's orders. But as I said, at that point, I felt I was doing well and I could continue with 30 pounds. So we delayed my restrictions so the management team could meet with the ADA team and discuss an alternative assignment for me. To my knowledge, that meeting did not happen. I know they did meet further with Shannon Meyer, but and that will be shown in later emails. But yeah, alternative assignment was not created. Let's see, and then this just discusses here's my doctor's note saying that I can delay restrictions until I'm continue to able to lift 30 pounds until I'm reevaluated on 7/21/22.
Are you on ERD 016 or am I supposed to be going this one? Is what you're on? ERD 017?
Yep, right there. Yep, that's my doctor's note that I added into the email chain delaying my restrictions.
All right. Go ahead.
Okay. Exhibit number 4 is just an email between me and employee advocate, asking, I'll just read it here. Hi, Shannon, please let me know what you find out from Dan and the zoo management today. I am home. I did not feel that I could deal with this in person this morning. I didn't know if they were going to send me with Eddie until they made a decision. Would I be training for a new job for 3 hours and then get pulled away? I did not know what to expect or what I would be walking into this morning. The situation is causing me a lot of stress and anxiety. I do not want to be publicly told in front of my coworkers that I'm no longer a zookeeper, nor do I want to be pulled in multiple directions throughout the day while management team is making a decision. I would like to be mentally prepared to start a new job tomorrow if that is the outcome. So please give me a call when you hear back from them. Thank you.
Attorney Mullen, was there an objection to C3 being admitted?
That
was the prior one, the email. I know you had objected to foundation that I wrote, but
yeah, I mean, I'm not objecting. I think I'm not sure if that was part of the stipulation or not, but I mean, I'm not objecting as far as she's saying that it's to show the restriction until that she had a 30-pound restriction until July 21st, 2022.
Right. And then C4, any objection?
No.
All right. Ms. Bertrand, you can continue.
Okay, thank you. July, this is an email from me to Elizabeth Peterson, CCing the other zoo managers and the employee advocate on July 21st after my doctor's appointment. Hello, this is the new letter from my doctor. I feel that Red Barn is too much for me at this point. It has consistent lifting throughout the day. I would feel more comfortable working in lighter areas such as Green Barn, Aviary, Herpetarium, Flamingo, Penguin, Porcupine, or Badger. I also need to know if I'm scheduled tomorrow. Senator, that's probably irrelevant. Since I was not scheduled as a zookeeper. And then the note from the doctor saying only to work if possible in an area that does not require lifting over 20 pounds consistently due to her pregnancy.
Right, and this is Exhibit C5.
Yes, sorry.
It looks like there's more of an email string that you want to cover that, or this is the
Yes, thank you.
portion that you want to cover.
Beth responded, based off your most recent doctor's note, your work assignment starting July 26th will be in operations department. And I will get with the Eddie and Kira to go over new job responsibilities in that department.
All right, Attorney Mullen, any objection?
I have no objections to this.
All right,
Okay.
Ms. Bertrand.
Yes. Exhibit 6. Emails between Elizabeth Peterson discussing new related tasks. This was sent originally on August 23rd. Should make sure, sorry, August 25th. We have some new ideas for animal related tasks, and we're hoping to set up a meeting to go over them. This is just discussing the new animal related tasks that they were going to provide me with. I said I wanted to meet sooner. And again, I reiterated if we can discuss through email, because we were having difficulty setting up a meeting, working with animals sooner and less. I would like to be working with animals sooner and less at the carousel. As I had previously stated, I do not feel the carousel is safer for me. Today, I was trying to communicate with the last child. She ran onto the carousel. She had no adults with her. She was climbing on the animals. I was trying to communicate with her to find out information about her parents. I had to catch her and assist her off the carousel animal. This exceeded my 20-pound weight limit. I have seen other volunteers have to assist children as well. Thank you. That's the end of that.
Attorney Mullen, any objection to it being omitted?
No.
Exhibit number 7 is just the incident report. Me sending basically the same explanation to the operations manager. A young girl opened the gate to the carousel, ran onto the carousel. The adults in line told the volunteer at the gate she was not with them. I walked around the carousel looking for an adult that might be with her. I did not find one. The child was running around the carousel and climbing on and off the animals. I called the duty manager and informed them that we had a child without a parent. I was trying to communicate with the child to get a description of her parents. I finally convinced her she needed an adult to ride the carousel. When she was climbing down from the carousel animal, she needed assistance. I had to assist her. This exceeded my 20-pound weight restriction. So it's just an example. Management said they were moving me for my safety, but when I expressed concerns about my safety and also that, emergency incidences were, could cause me to lift more in that area, they still continue to schedule me in the carousel. That's the end of that.
Any objection, Attorney Mullen?
No objection to that.
Exhibit number 8, email from zoo manager explaining how zookeepers can work together to accommodate a zookeeper with the light duty restrictions. This email is from Catherine Piniowski, our zoo manager, emailing the entire aviary team, letting them know that we had a worker with restrictions and that we were going to split the aviary differently. The aviary has 2 workers in it daily, so that is why one of the reasons why I felt that that would be an area that I could work in with restrictions. It says, "Hi, aviary keepers. Eric has returned to work with some restrictions. The aviary splits will look a little different when Eric is scheduled in there for the day. Please work together to figure out how to best arrange the day. Eric can assist with diets, bats, parrots, watering free flight, feeding out free flight, enrichment, and disinfections. Eric cannot assist with otters, fish tanks, cappy, any life support, backwashing, or waterfowl cleaning. Any questions, please ask for clarification." Just an example of how we offer light duty work at the zoo.
So I do object to this. Again, it is from a date in 2023. Additionally, to the extent it involves her witness, that her witness can lay the foundation for this document, but I don't think it should be admitted at this time.
Yeah, so I will say, Ms. Bertrand, I'm going to assume that you're going to try to get into it with your witness,
Yes.
which might give it more clarity.
Okay.
It will have, limited significance without the context that I'm sure the witness can provide. I will say that it can be admitted as an exhibit, but hopefully, Ms. Bertrand, your witness will get into detail because it will have some limited significance.
Okay.
I'll allow it to be admitted.
Thank you, Your Honor.
Mhm.
Exhibit number 9. This is a letter of commendation. I felt it was worth adding just to show that I had a positive working relationship with the zoo management prior to leaving the orangutan area. This letter was written because I had made a mistake with the lock. That's the I reported my mistake, and that was during a time that was we were working around the clock to care for an injured orangutan, or a very ill orangutan. And so Beth felt that, and Rhonda both felt that, to show that, I made this mistake that I self-reported during a stressful time, they wanted to also add this letter. When they had to give me a coaching note for making a mistake, they wanted to also add this letter into my file at that time. October 1st, 2019, letter of commendation. Dear Susan, during the last few weeks, we have faced a new and challenging hurdle as we've navigated a critical care case with our orangutan Kawan. The situation required long hours, overnight commitments, and high level of communication with veterinary and keeper staff. Seemingly, fingers crossed, we have seen Kawan through her paralysis, IV fluid support, 6 sedated procedures, and supportive care in the building. We could not have done it without you. At different times throughout this case, we have needed support from many different zoo staff. It has truly been a team effort, but the primate team has risen above and beyond in caring for this special girl. Thank you for staying late. Thank you for coming early. Thank you for sleeping over. Thank you for juggling other animals while also carving out time to check on Kawan or relieve teammates for lunches or breaks. Thank you for contributing to hard but necessary meetings. Thank you for being solution-oriented and keeping Kawan's quality of life at the core of our goals and conversations. Thank you for many sacrifice hours away from family, friends, and non-zoo life. Henry Violet SU is lucky to have individuals like yourself that stick with it when times are tough and continually add to what makes our zoo team great. I am so proud of our primate team. I can't say thank you enough, and neither can Kawan, though she isn't really into thank yous. Beth Peterson, Zoo Manager, Interim General Curator.
Um,
Any objection, Attorney Mullen?
I mean, I guess I do not object to the fact that to the extent that she's just showing that this letter was sent to her. I mean, it has nothing to do with any of the issues in this case, so it's completely irrelevant. But I don't object to, I guess its admissibility.
All right. Then I'll allow it to be admitted.
Thank you.
I will, before she gets started on the next one, I will say that I object to exhibit number 10 as cumulative, as it essentially states the same thing as in exhibit 9.
Okay. Sorry, do you want my explanation?
Sure.
Okay. She's correct. It does basically say the same thing. It's just this email is from our director showing that, I had a positive relationship with Beth and our director, Rhonda Schwetz.
All right. Well, I'll allow it to be admitted.
Okay. Exhibit number 11, when I had asked to leave the cat area, management asked me to reach out to the ADA coordinator. So this is just an email showing that I reached out to the ADA coordinator asking for help to leave cats. I don't know if you want me to read all of it or if you just want.
So I do not need documents read necessarily, but
Okay.
is there ever a key point that you want to read, you can.
Okay.
I will say that, you don't have to just be stuck with what's in the exhibit.
Okay.
And I know you gave opening statements, and this is sometimes a problem with opening statements, is that people then feel like, well, I've said everything.
Okay. Yeah.
But technically speaking, the opening statement is just a roadmap for what's going to come. So typically, you would kind of discuss the situation. An exhibit comes up in that timeline, you might address it. So just to caution you that you don't have to just say, okay, here's exhibit 1, here's exhibit 2, here's
Okay.
exhibit 3, and then just kind of that's your timeline necessarily. But otherwise, I know how to read. The document can speak for itself. But, if there's key points, obviously, I fully understand people wanting to read key points so that they're not missed, especially since I need to know why it's relevant. Now, obviously, there you gave me the summary, so I know why it's relevant. But if there were anything else that was important, then you certainly could read it. But I do not need everything read, no.
Okay. Thank you for that explanation, Your Honor.
Are you covering, is this an additional part that you're covering? Or was it just, they're essentially the same thing? Because it looks like there's another part from.
Let me see here. Let's see. That is a response from Eric Anderson. I involved the employee group at this time because to my knowledge, I had never heard of the zoo management asking anyone to get ADA accommodations to leave animal areas. So I was just kind of reaching out. I did what they asked. I reached out to the ADA coordinator to see if this is something that that she could help me with. Is this an appropriate way to handle this situation? And then I also CC Shannon Meyer, the employee advocate, and then our union president. So that was just his response to my email saying that, and actually his probably says more than mine, so I could just point out, The zoo leadership team had plenty of time to train replacements. I've been very patient with them. And that each day that I've been scheduled to work in cats, there's been another cat keeper available. So that was not what, I was told that I would be used as needed, if needed, to work in cats. And obviously I wasn't needed. They were just scheduling me more and more in cats. So this was just an example of me reaching out to HR and the employee group.
Any objection, Attorney Mullen?
No.
Number 12, this was just saying that I've missed some work from anxiety.
So I object to this as it's not part of a probable cause hearing. My understanding from when she produced this in discovery was that it was speaking to damages, which are not a topic of the probable cause hearing. Not to mention that the dates are in 2023.
Right. So what are you trying to show with this, Ms. Bertrand?
I think it goes back to where just of this case and the treatment from management and the continued retaliation has caused me stress and anxiety.
All right. Well,
So
I mean, obviously you can speak to that through your testimony.
Okay.
But as far as the document, I don't know if the document necessarily shows that. I mean, I guess you're trying to show that you took FMLA and then you're trying to say it was because of that. Yeah, I mean, it says that it's after the fact. I don't know that the email provides anything other than, I mean, I guess proving that you took FMLA, and even then. Yeah, I mean, I guess I don't see the significance of that to the case. I guess I'll let you respond to that. So I don't know how it proves, so to Attorney Mullen's point, right? So you're trying to prove discrimination during the time frame that you stated in your complaint. And I guess this is trying to, I guess your argument is this is validating that there was discrimination because of the impact on you, but I don't know if this email provides that. And I'm not sure that necessarily stems from it. I'll let you respond to that, I guess, if you think you need to.
There has, obviously this case is stressful. There has been continued retaliation since this case, which is probably not, like you said, I don't know if that's in terms of a settlement. When I had asked for additional VOL time because I was denied a 0.6 full-time position, that is an example of retaliation. And
so I want to jump in right here because we are not, this is not a hearing on retaliation.
Right. Right. So the issues, and I did, read them at the outset, right? So you're trying to show that the county discriminated against you in terms of conditions of employment because of sex, discriminated against you in terms of conditions of employment because of pregnancy, and then discriminated against you in compensation because of pregnancy. I am going to go ahead and exclude this exhibit. I mean, obviously, you're free to testify as to how some of those discriminations impacted you, but I don't see the significance of this document, so I'm going to exclude it.
Okay.
You can continue.
Okay.
13.
Yeah. Just
Continue
this
13.
is exhibit 13 is just an example. Let me see, sorry. This was me reaching out to the employee advocate and just expressing concerns about discussing my situation with zoo management. They came back, I asked, is this something I'd get ADA accommodations for? They came back and said that, I should be able to get accommodation under the Pregnancy Non-Discrimination Act. Okay.
Attorney Mullen? Any
I don't
objections?
object to this. I believe it actually, it's one of my exhibits.
Okay.
So,
Okay, exhibit 14, emails. With Ellen Dirge and Shannon Meyer. This is when I said, hello, Laura Weiner informed me today that she and Beth will be scheduling a meeting with Dan Lowndes. They want us to discuss my restrictions and what is expected of a zookeeper. I feel that they are going to try to transfer me. My doctor said that the most important thing I can do for my health is to stay in shape. Starting July, my doctor put me on a 15-pound weight limit. This should not be a problem. I have been on a 10-pound weight limit with a previous back injury. She also said that I will not be able to climb. There are a couple unsafe climbing spots in the aviary, both of which should be fixed. Let's see. Just went on to talk about that. And I just asked that we make the zoo a safer place. So this is mentioning that I've worked, that number one, I was concerned that they were going to move me out of working with animals because that is something that management does for punishment. And that I have worked with a 10-pound weight limit in the aviary before, which is why I suggested the aviary, because I've been allowed to work in the aviary before.
I'm not objecting. I guess if to the extent that this document is meant to show that she told someone these things, but as far as the truth of the matter of any of the statements made in here, I mean, she can testify and prove her points as to that, but I don't, this document should not be admissible as proof that anything she's saying actually occurred the way it is described in this letter.
You want to address that, Ms. Bertrand? That argument.
Well, it does seem to show that there's a history of expectations in terms of what work areas can be considered light duty for. If she was working this area before with a 10-pound restriction, I suppose if maybe you'd want, an email corroborating that from management, I suppose. But this correspondence between her and Ellen Dirge, the ADA coordinators, Susan basically reporting a situation that she was in that matches what it is she was requesting for her, as evidence that there is available, like there are work assignments that are available that would fit the light duty assignments she was requesting. Does that make sense?
Well, the problem with that is that she's conveying this information that she was informed of something by somebody else, Laura Weiner, who's not a witness in this matter.
Okay.
Yeah, so obviously that's a concern, right? So I understand that this is an email that Ms. Bertrand sent, right? So, but she's conveying information from someone else, which would then make it hearsay. Now, again, we can't accept hearsay in certain situations. I would tend to agree that, the email can show that she made this communication, that she, raised these concerns, but as far as the individual components of it, it's not necessarily going to be sufficient to prove those pieces. So just as a fair warning. So it will be admitted, but just understand that it's being admitted to show that Ms. Bertrand, you raised these issues, and not necessarily proving the underlying facts. If that makes sense.
Thank you. Exhibit number 15 is just an email from employee advocate discussing uncertainty of schedule. This was just, I felt, to show that this was July 13th. You know, I was working with not really knowing what was going to happen, because I kept being told that maybe more meetings would come, more discussions would happen. I felt that this was not really dealt with in a timely manner, because at our initial meeting, they said that, you know, maybe they'll have me work the carousel, but it sounded like we would be meeting again to discuss other possibilities of work that I could do. So I felt that this was just showing that, like I said, this was really not dealt with in a timely manner, and I had a lot of uncertainty about what my future was going to be and what my job assignment was going to be.
Any objection, Attorney Mullen, to this exhibit?
No.
Okay, exhibit number 16, again, this just shows that, it was my understanding that they needed to have a reason for them to deny me light duty, as they've given light duty to other, zookeepers, including myself. Mary Schmidt was someone who near her retirement, she was just physically, you know, she was near retirement age. She was physically struggling to do our job because it is a physically challenging job. And so she was given easier schedules. Flamingo Badger was an example. Those are areas that they kind of considered to be add-on areas. Generally, you would work like aviary flamingo or red barn flamingo, but she was just given flamingo as her task for the day, which is approximately like 2 hours of work. Sometimes she would have flamingo badger, which again, badger is approximately 2 hours of work. So she was regularly given schedules that were half the amount of work that most other zookeepers are given. I had asked sorry.
Oh, no, go ahead. I mean, I'm going to object to this for the same reasons as I stated before, that, you know, that there's multiple hearsay statements, things that were told to her by other people. I don't think any of this is admissible for the truth of those matters asserted, to the point that she sent this email. I guess it could be admitted for that limited purpose, and but otherwise, I don't, nothing that is stated in here has been proven by the fact that that she's presenting this document. She doesn't have these people identified as witnesses.
Ms. Bertrand, do you want to address that?
Yeah.
So Ms. Mullen it says that they are going to prove that they kept Susan employed and compensated, and it's not exactly what Ms. Bertrand is claiming happened here. She's the point of these exhibits is to show that she was treated unequally. I know that we're not hearing a case on retaliation and intimidation, but that is one of the reasons why she's found it hard to bring witnesses forward, in that the zoo has a pretty substantial history of intimidation, and a lot of workers aren't willing to.
I completely
come
object to
forward.
that statement. I mean, that
Yeah. Well, I'm just explaining why it is she's had a hard time bringing
That's
bringing forward
argumentative.
witnesses.
Yeah, so that is going to be argumentative. So I will say that I have the same. I will allow the email to come in. I have the same concerns about it as these are hearsay statements. You know, this is an email written by Miss Bertrand, so it's kind of a self-serving, you know, document. I understand it was potentially before, yeah, her complaint, but it's hard to rely on the hearsay statements, especially if it's going to go to a material issue. And I mean, this is a material issue for her case, right? Is that other people either received accommodations or they were permitted to, you know, adjust their work environment. I use the two phrases because there's the legal accommodation and then there's the not one. And remember that this is the Wisconsin Fair Employment Act. This is not the Pregnancy Non-Discrimination Act that we're dealing with here. And so this is going to be a material issue, is that you're trying to show that other people were given this ability to, you know, work in these light duty areas, either whether they were pregnant or for other reasons, and that you weren't. So when you have these hearsay statements where it's basically just the complainant saying this, that other people either told her or that she thinks, you know, happened, it's hard to rely on it without more concrete evidence. So that's the concern. It's going to be admitted as an exhibit, but, you know, as far as proving the underlying truth of the statements, I don't know that it's going to be used for that purpose.
Okay, thank you for the explanation. Okay, do you want me to continue to go through each exhibit?
You
Or-
go where you want to go.
Okay.
And again, I'm not going to require you. You don't have to just go exhibit by exhibit or in order of exhibits. I mean, you're free to testify. And I know you did some of that kind of in your opening statement, but that's technically not testimony. But yeah, you're free to go however you want to go. And it does not have to be in the order of the exhibits. I mean, if you have them ordered appropriately, that's fine. But sometimes people put them together and then they have to jump around.
Yep.
That's fine. I mean, it's usually best for you just to testify, and then exhibits kind of come in as you reach that point in your testimony. But you can do it how you want to do it.